Hello, everyone, and welcome to episode 6 of the Exeter Law Review podcast. My name is Shania Isa Aurelio. I am the co-editor-in-chief of the Law Review this year. Today, I am joined by our General Secretary and one of our managing editors, Selin Uyguç, who will be having a discussion with Dr. Rebecca Helm. So they will be discussing Miscarriages of Justice in the UK, their pro bono project, that focuses on the topic, keep that in, their experience working with Clive Stafford Smith, who is the founder of the human rights nonprofit Reprieve, and the possible impact that COVID-19 has on the operations within the criminal justice field. So just a little bit about Rebecca. She is a UNRI Future Leaders Fellow and a senior lecturer at the University of Exeter. She has a PhD in psychology and law from Cornell University, a master's in law and a master's in psychology from Cornell University, and a BA in jurisprudence from the University of Oxford. She is a qualified solicitor in England and Wales and an attorney in the state of New York, US of A. So without any further ado, Selin, take it away.
Thank you, Shania. Rebecca, thank you so much for joining us today. We can see from your path that you've had quite an interdisciplinary journey with law in your career thus far. And was this what informed your research subject matter, but also your approach in assessing various types of miscarriages of justice?
Yeah, so initially when I was doing my BA, I wanted to go into commercial law. But during the year that I had between graduating from my BA and starting my training contract, I was doing a master's degree in the United States. And I took one course, which was a course on neuroscience and the law, which kind of talked about the implications of neuroscience for the legal system. And I became really interested in this idea that as lawyers, we can understand science and we can use science and also these kind of scientific methodologies to better understand the legal system. So here's kind of the idea, and what I got really interested in is that the legal system itself is really a system that is all about humans, right? It's all about people. The legal system is set up to regulate, to change human behavior, and both civil and criminal litigation are very much reliant on humans deciding what's true, right? Juries, judges decide what happened. That's how we litigate our cases. So to be effective, the legal system needs to understand how human decision makers work. And I think what I increasingly realized is that one mistake that the legal system has made is thinking that we understand how human decision making works. I don't know how much you'll know about human psychology, but actually half the time we don't understand our own decisions, let alone anybody else's. And we see that a lot in the legal system. We're presuming that juries, judges, citizens can do what they're asked to do. And actually, it's much more complicated than that. We don't really understand the psychology of others as well as we would like. So one example is if we look at false confessions. People really think that no one would confess to committing a crime unless they did it, absent kind of physical pressure or threats. But we know now that that's really not the case at all. So what I wanted to do is use behavioral science and use data science to improve the legal system, and also to integrate research from those disciplines into the arguments that we make as lawyers. So arguments about which kind of cases we should be selecting for appeal, and also kind of human rights legislation, right? We can infringe on specific freedoms provided that it's necessary and proportionate. But how do we know what necessary and proportionate means? So this brings me around to kind of my interest in miscarriages of justice and the angle that I come at this stuff from. Both the civil and criminal justice systems obviously rely on judges and juries being able to make good, accurate decisions, let's say, to determine what's true to whatever threshold we're using. And so we need to understand how judges and juries are making those decisions and when they might be making mistakes. So when we look at this method we have for determining quote unquote, like truth in the legal system, it looks very different from any mechanism we would ever use in science to determine truth, right? We have this idea that somehow 12 people sitting in a room can somehow determine what happened. And that's particularly problematic when we look at interpretations of things like psycho-legal constructs. Consent is a good example. You know, you want to determine whether a complainant in a sexual assault case consented. You're going to sit 12 people who may or may not have any experience of sexual assault, who are completely random, and they're somehow able to get inside that person's mind and determine whether they provided meaningful consent. And actually, the more we look at these kind of decisions, the more we realize that jurors aren't doing what we want them to be doing. So in the case of consent, to give a basic example, we know they're relying quite heavily on things like rape myths, which impedes their decision-making. So what I wanted to do, and what I guess I've been trying to do over the last 5 years, is to mirror the way that we kind of develop and test tools in the physical sciences, but in the legal system. So in the same way as we develop and test those tools in physical sciences, we can actually develop and nuance these mechanisms of using human decision makers effectively in the legal system to help them make more accurate, more fair determinations. Obviously, miscarriages of justice is an area this is really important. And then I'm also interested in what you might call wrongful acquittals, right? Systematic failures to prosecute in certain types of case. And also in the civil context too, where there's systematic biases and mistakes being made, which are prejudicing particular categories of plaintiff, particular categories of defendant. So that's really kind of the angle that I'm coming at the miscarriages of justice issue from.
Definitely. And I think with the, with the complexities of all these systems and how inadequate they seem to be, they're facing an unprecedented obstacle right now, which is the pandemic, obviously. So, alongside everything else, access to justice also becomes more blurred and more complicated in this climate. And so I wanted to ask you, what do you think the impact of COVID will be for possible failings in the system in the long run, especially on top of the legal aid crisis in the UK right now?
Yeah, so I mean, I think that's really important. Like you mentioned, there's already this issue with legal aid. The criminal justice system is already hugely struggling due to legal aid cuts, due to kind of what we might call chronic underfunding. And I think the impact of COVID has been to shove like a load more pressure on a system which ultimately was already failing and struggling. And one of the things we've seen in the immediate term is these huge backlogs picking up in the courts. So there was already a relatively long delay, right, between getting accused of a criminal offense and getting your case actually heard in court. But that delay has just got bigger and bigger as we've had to postpone cases because we can't have people physically in courtrooms. So I think currently there's something like 500,000 criminal cases waiting to be heard. The last I knew until this morning, cases were being scheduled for 2022, but actually I read something this morning that said some cases are now being postponed until 2023. So we've got people accused of criminal offences who are really having to wait a long time to get their case heard. This is problematic for everyone accused of a criminal offence, right? But it's particularly problematic for people who are remanded in custody. So there's this group of defendants who have not been found guilty of an offence, could quite possibly be acquitted at trial, who are having to sit in prison, in remand institutions for very long periods of time. You know, we're talking about a year or more without ever having even had anyone hear their case. So this is problematic for the presumption of innocence, right? And I think one of the really big challenges is going to be deciding how to deal with that, how to get through these cases. So there's a number of different kind of ideas being thrown around. But one thing that's really being drawn on a lot, which I think will be kind of one of the long-term impacts of COVID, is this idea of holding justice procedures online. And to what extent can we utilize online technology? Can we utilize kind of remote appearances in order to process these things more quickly particularly in the context of something like a pandemic where we're really reducing footfall or trying to reduce footfall into the courts. And so one thing I've been thinking about a lot is this idea of justice going online. How can we think about that carefully to make sure we can utilize it appropriately? Because I think it can be helpful. So one of the things we've been doing in my research group is trying to gather empirical data on online justice so we can understand what the impacts of it are. And there's a few potential problems with online justice that I think we need to iron out. And if we don't, then potentially this really fast switch to online justice procedures could be really problematic. One of those, which was identified by one of my collaborators, a lady called Penelope Gibbs, who works for a charity called Transform Justice, is that we're really meant to have an open justice procedure so that people can see justice being done in the courtrooms, right? In theory, you can access online magistrates' courts. Penelope has been trying for a while, and I understand that it's very difficult to the extent of being near impossible for some cases. So we're losing that kind of transparency. But the issues that are kind of more relevant to me and my work are with the way that online justice might impact the experience of defendants, and particularly leading defendants even to be convicted of crimes they didn't commit. One big problem that we have is communication issues. So I don't know if you experienced this when classes all switched to online this year, but it's very different communicating with people online than it is communicating with people in person. To some extent, we've got used to this, we can do this, but there are particular groups of people who are going to really struggle to do this. And you have to remember that people interacting with the criminal justice system won't necessarily have the experience with technology that we have. They often have vulnerabilities, learning disabilities, autism, and autism spectrum disorders is a big one, which actually makes it much harder to interact meaningfully with people over kind of video conferencing technology. So I think this creates this situation, which I just wrote an article about recently, which is coming out soon, where defendants don't necessarily understand the case against them when they're being asked whether they want to plead guilty. And guilty pleas are something I'm really interested in. So we're potentially having defendants who are pleading guilty because they don't feel they can interact with a trial process, they just give up, or even because they think that they've committed a crime when they actually haven't. And this is the kind of situation where they know what they did, but they don't know that actually there's a defense they could use, because they're not having that kind of dialogue with their lawyer where they can really engage and understand these things. And so we do have empirical evidence that guilty plea rates go up when justice goes online. And so I think we need to be alert to kind of these long-term threats of moving justice online that we have to address if that is going to be one way that we kind of rebuild and deal with this backlog.
Definitely. And also there's the issue of the closure of forensic science services, and the House of Lords report emphasizing the increasing privatization of forensic science services now. And there have been instances of cyber hacks like the Eurofins incident, and also the Randox incident relating to drug driving offenses. What do you think are some alarming realities in the current system, like manipulation of data in this instance, and how can they affect trial outcomes?
Yeah, so I don't do a huge amount myself on forensic science, but I've learned a lot. The postdoc working in my group, Beth Browns, she specifically studies forensic science. And so she would be a really interesting person to talk to in more depth about these issues. But as you mentioned, there's all these problems with forensic science. The UK has traditionally been viewed as a very strong jurisdiction when it comes to utilizing forensic science, and that House of Lords report and the opinions that went into it were fairly damning, right, about the state of forensic science.
Yeah.
Here, I have kind of mixed opinions about forensic science, and I think there's kind of two issues, right? One is we're using weak forensic science, and that's resulting in innocent people being convicted, and that's something that I know a little more about. The other side, which I think was maybe brought out more in that House of Lords report, was we are not catching enough people who committed crimes because we're not good enough at using forensic science techniques and developing forensic science techniques that we can use to catch them. And they're both interesting. They're both interesting questions. But I think for me, there are kind of fundamental issues with forensic science and its use in general that makes me kind of reluctant to expand it into those new areas that it potentially needs to be going to allow us to improve crime control until we've addressed them. And data breaches are definitely important, but I think we have kind of even more fundamental issues. And what a lot of people don't realize, and what Beth and her research really brought home for me, is that outside of the sphere of kind of nuclear DNA analysis and chemical analysis, really forensic science is just sophisticated opinion evidence, right? We're asking very qualified people, you know, what do you think? And so it's not as objective as people think. And this is particularly bad in the United States, where they allow all kinds of forensic science into the courtroom. They call it junk science in the literature, you might see. And this is a range of evidence which really is barely probative at all, and which is being presented to jurors as if it's quite conclusive. So one example is bite mark evidence. Bite mark evidence continues to be introduced in the United States, despite the fact we've shown that it can't really identify who committed crimes. But even here, there's problems with that, right? There's the case of a guy called Mark Gallagher, and he was convicted on the basis of ear print evidence because they found some kind of ear print that he was meant to have left on a window. And that was completely discredited, and his conviction was overturned. But he was in prison for 7 years before anyone said, wait a minute, like, what about that ear print evidence, you know, made people think that it could actually prove guilt beyond a reasonable doubt. So one of the big problems that I see, which is a bit more of like a fundamental issue in forensic sciences, is the reliance that we have on jurors, but also on judges, to really be able to distinguish reliable and unreliable forensic evidence, particularly in an adversarial system. And I wrote about this a bit in 2017 with a couple of collaborators from the United States. There's been a reasonable amount of research that shows that jurors essentially don't really do a good job of distinguishing strong and weak forensic evidence. And they're tending to rely on what we call heuristic cues when analyzing this evidence. So a big one is the expertise of the person, right? You see someone very experienced, you're likely to believe what they say. But there are problems with this. I think this might be the only context in which we as kind of lay people are asked to examine medical opinions and determine how valid we think they are. So you have some doctor who's a really distinguished pediatrician, they're giving you their opinion, it sounds very sophisticated, they sound like they have a good basis. And you as the jury, I'm gonna sit there and say like, oh no, I agree with the other expert actually. And we're not well qualified to do it. Usually experts are good, but I think some of the biggest problems come in where experts aren't good. And that's almost an issue of kind of ethics for those experts themselves. So one big example in England and Wales is a pediatrician called Sir Roy Meadows, and he was a very distinguished pediatrician. And he gave evidence as to the cause of death of children in a number of cases. One of those was a woman called Sally Clark. That's probably the most well-known. But these are often women who have had 2 children essentially die from cot death, sudden infant death syndrome. And now scientifically, we know that if you've had one child die from sudden infant death syndrome, unfortunately, you're more likely to have another child die from sudden infant death syndrome because there's some kind of inherited functionality to this, right? They don't really understand it, but if it happens once, it's more likely to happen again. But so Roy Meadows testified in the cases of these women that it was hugely unlikely a woman would ever have 2 children die of sudden infant death. I think he put a figure on it. He said it's like 1 in 73 million is the chance that a woman would have 2 children die of sudden infant death. Of course, the jury, this sticks in their minds, right? They're not equipped to really critique this. Anyway, it turns out that it's wrong. And he did get struck off. But Sally Clark herself ended up dying a few years after she was released. she developed alcoholism as a result of this like horrible experience that she went through. And many women spent time in prison as a result of the testimony that this guy gave. And I think the question is, how can we catch things like that kind of before they get into the courtroom, rather than catching them afterwards through the appeals process? Partly because not everyone can afford to appeal their case. Not everyone can get the attention of a lawyer who's willing to help them, who's willing to really dig into these issues. So I think there are big problems there. The one area I would really like to see forensic science strengthened in, and this is partly my bias, is in utilizing forensic science for exoneration. In the United States, if you look at the registry of exonerations, a huge number of people who have been exonerated following conviction are exonerated fairly conclusively on the basis of DNA evidence, which shows that they couldn't have committed a crime. Most often in like rape, murder cases, these kind of violent cases. In England and Wales, in the whole of the UK, it's very, very rare that forensic science is used in that way, because we don't have this kind of investigative, meaningful scientific approach to identifying wrongful convictions, partly because we don't have the funding for it. And I would really like to see forensic science stronger there, because we do have the expertise, we have the science to do it. And so I think that's important. And there are organizations, Appeal, formerly the Center for Criminal Appeals, is one that is starting to use that investigative approach here. So I'd really like to see forensic science grow in that way.
And then you would be inclined to agree that there needs to be, necessary collaborations between these ecosystems of criminal justice and research and, investigative psychology, and that these problems and this chaos is not solely due to a lack of funding.
Yes, definitely. And I think if I was going to prioritize funding for something in the criminal justice system, it's certainly not the first place that I would go. I think, like you say, it needs people to work together. So what I would love to see is kind of forensic scientists, behavioral scientists, lawyers get together and really think about how can we present this evidence to judges and juries in a way which is actually meaningful to them and is going to help them make the right decisions, rather than thinking, okay, it's an adversarial system, let's play on jurors' biases to try and convince them, of the side that we want them to be convinced by.
Definitely. And obviously you've been working with Clive Stafford Smith, and I'm also extremely excited to start on our project that we can't really disclose yet. But for the part that you can talk about, how has it been working with an individual that is so influential in the criminal justice sphere?
Yeah, it's been fun. So we started this project kind of the year before you came on it. So I guess I've been doing it almost 2 years now. And it's fun. Clive is always someone who really is never afraid to speak his mind. He has a lot of relatively extreme views. You're always kind of biting your nails when he comes and gives a talk, and everyone knows that like you're the person who invited him. He's like not a fan of a lot of things which other people do like, and he's quite skeptical of like authority and authority systems and this kind of thing. But that's what makes him a lot of fun to work with. I think he kind of reminds us that as lawyers, we're part of a system, right? We receive legal training. We buy into a lot of ideas which the legal system buys into. Punishment's one of them, right? We all think we should be punishing people who have committed crimes. But his experience is kind of unique, and I think it allows him to challenge even some of the more basic assumptions that we have. And so that's really fun and it's really interesting. And I love seeing how he interacts with students, because I do think students enjoy talking to someone who's kind of less constrained by what a university lecturer should look like and should say, and he can be kind of more free in sharing those opinions.
For sure. And moving on to talk about our project. For our listeners who may not be aware, what is the evidence-based justice lab and the Miscarriages of Justice pro bono project?
So the evidence-based justice lab is my research group here in Exeter. Essentially what we do is we use behavioral science and we use data science to examine the legal system, and also to look at how changes in law and policy might be used to enhance that system. and its effectiveness at achieving what we might call like normative goals of the system. So really, we're an empirical lab. We use psychology, we use things like modeling, we use experimental methodologies, and we look at the practical effects of changes in legislation. You know, what's actually going on in the legal system, what are laws actually doing, rather than just what we think they're doing and what seems good at a theoretical level. So a few examples, we've looked a lot at innocent people pleading guilty. When and why do innocent people plead guilty? How can we tailor legislation so that innocent people are likely to go to trial, guilty people are more likely to plead guilty? We've looked at legislation to combat fake news. So how can you effectively prevent people from believing fake news and these kind of infodemics that we're seeing recently? We look at how juries work as decision-making bodies. Not just what do we think juries are doing, what are they actually doing? How are they functioning as this kind of legal machine, right? I'm doing a project at the moment, which is pretty interesting, with a collaborator from Cornell University, where we're looking at the relationship between regulation of abortion and child marriage, two things that you wouldn't necessarily put together, specifically in the Indian context. So a lot of really interesting work, but all united by this idea of using behavioral science and using data science to better understand and improve the system. And the Miscarriages of Justice pro bono fits into that. So we have a clinical part of the research group, and that's the part which is less directly research facing and is more community facing. So we're thinking about how can we use our work and our expertise to help in the community and to help project partners who are doing work in the community. So we've just launched this database, which obviously you helped with putting together, which kind of makes searchable this collection that we've gathered of miscarriages of justice resulting from poor evidence evaluation in England and Wales, and actually also in Scotland and Northern Ireland, with the idea being that we can help people who are potentially victims of miscarriage of justice, help practitioners working on those kinds of case, and then also doing some work kind of a bit more directly on actual cases of potential actual innocence, cases of miscarriage of justice, which is where the work with Clive comes in.
Definitely. And what was your realization that, you know, there was a gap in the system and a need for clear, accessible data compiled in one place, informed by? Because I did realize when I was doing the research that, you know, I couldn't really access these cases and these facts, you know, as easily as, you know, it should be. And there are like some databases, but it's just, it just didn't feel accessible at all.
Yeah, this is a big problem, I think, here. And one of the reasons that I kind of knew how helpful it would be is because they do have a similar registry in the United States, which is called the National Registry of Exonerations. And when I was conducting research and trying to make my research meaningful and understand how it might apply in real cases, I would refer to that database all the time. You know, as academics, we can do a lot of work on an issue which is academically interesting and really makes no difference to anything. But I think particularly as academics who are lawyers, we really have this opportunity and this responsibility to use our work and our expertise in a meaningful way. So one thing that this can do, like creating this kind of database, is it can allow researchers to target areas where there are clear issues with evidence evaluation. One of them is obviously witness testimony, right? I was looking at the database after we compiled it, and we have this big issue, which is really evident from that database in sexual assault cases involving sexual offenses. We see this huge recent bulk of miscarriages of justice involving sexual offenses, and often it's based on witness testimony. But the really interesting thing is, alongside that, we're seeing this real systematic failure to prosecute cases of sexual assault. Where you know, real victims aren't having their case heard and are being discriminated against. Things like rape myths are making a difference. And I think you can see from both sides of that coin, like we're not doing a good job in how we investigate and how we adjudicate sexual offences. And there's a whole range of problems that come into that, which I won't go into now, but I think having that visual in the database, seeing the real people who have been involved in this, knowing like this is a problem, helps us target research in a useful way. So that's why I kind of knew there was a need for it. And then I also started working with practitioner partners who are adjudicating and investigating cases of potential innocence on a day-to-day basis. And so I worked with them in kind of understanding their need and how important this could actually be for individual cases as well, helping to progress those.
Mm-hmm. And what made you want to include Exeter law students in, such an active role in the clinical team? Because I did feel very much involved, which was amazing. So I wanted to ask you, what was the motivation behind it?
Yeah, well, good. I'm glad. I'm glad. It's I managed a research lab when I worked in the United States. So I had a group quite a lot bigger than our group, where we would involve students in research, involve students in real projects. And often those projects ended up being things that we could publish or things that were useful in actual cases, And I learned a lot through that experience because it was great. And firstly, it was a great educational experience for students, and it's wonderful to kind of share that. And I think there's something in the idea that you can learn more when you're doing something rather than when you're kind of sitting in a classroom having someone talk to you, although there's a place for both of those things. But I also love the idea that like university isn't just about students learning. It's about kind of forming these relationships between students and between kind of more experienced experts in their area, and thinking, how can we work together to really produce something wonderful, to really make a difference in the community, right? So we are learning, but we can learn through working together and learning from each other, these kind of collaborations. So we're doing something that makes a difference and kind of all learning from that in the process. So I love that. And that's why I kind of wanted to do it. The other side of it is that it was just so valuable to have the support of people who really cared about social justice as well, working on this with me, right? And I had a number of student research assistants involved in various different ways, but it was so wonderful to see people who were really enthusiastic about social justice, preventing miscarriage of justice, and really invaluable on the project, because I couldn't have done all this by myself. It's a huge task, as you know, it doesn't seem like that much, like going through that many cases, but it turns out it's a huge task. And all of the students actually who've been involved have done a really, really wonderful job. So definitely thank you to you and the other students, because selfishly, that was kind of my benefit from it. I think the database looks a lot better because I've had that help.
Oh, thank you. I think these interactions are so important, especially in the current climate, because the way we interact is different, and our communities feel different. So I think this definitely has a important place in the world of today. And in our very first episode this year, we actually talked to former Judge David Tyzak on access to justice and COVID specifically. And an interesting point of intersection that I noted was how problems with access to justice could actually bring about miscarriages of justice. So I wanted to ask your opinion on this as well.
Yeah, one of the areas that I'm most interested in, that this comes up in a lot, is looking at guilty pleas. And I really strongly feel that our current guilty plea system does restrict access to justice. So in theory, everyone has this right to a fair trial under the European Convention on Human Rights. But then at the beginning of your trial, you're asked, do you want to plead guilty, or do you want to actually have your case heard at a full trial? And there's really compelling incentives to lead you to plead guilty rather than to contest your guilt. Mm-hmm. And this is somewhat problematic, right? People can't really access the justice system because they're really being incentivized to, and almost to the point of coercion, to end their trial process there, right? To plead guilty. Mm-hmm. And in my work, I kind of look at some of these examples about why people might plead guilty, why people might not actually be able to access meaningful justice. So I can give you a few examples, which are kind of the more intuitive examples. So one of them is there are some situations, they're rare, but not as rare as you'd think, where people are remanded in custody, and if they plead guilty, they can get out of custody. More common in the United States, but it happens here too. So particularly if you're a single parent, if you're going to lose your job, if you sit in remand for much longer, and you know, oh, if I just say that I did it, I can get out, next week. Of course, people are going to start pleading guilty because trial feels inaccessible to them, right? Like, I can get out, I can't afford to sit here any longer and wait to be able to contest my guilt at trial. Another one is the time and cost that involves in trial. This is legal aid cuts. I'm sure you will have heard a fair bit if you've been talking about criminal justice, about legal aid, but certain people can't actually afford a lawyer for trial, but they can afford a lawyer to kind of help them plead. And in that case, they're much more likely to plead. The other one is some defendants will know that they could go to prison if they're found guilty at trial, but they can actually eliminate the threat of prison if they're willing to plead guilty. So all of these things really have quite clear potential to lead innocent people to admit guilt and to prevent innocent people from actually being able to access the justice system.
Definitely. And for our last question, I wanted this to be more of a general one. What do you think are the main challenges and the kind of necessary improvements, specifically speaking for the UK, in the criminal justice arena?
This might be a bit of a boring answer, but I think probably the answer that most people would give you, it's probably unequivocally right, is funding in the criminal justice system. It's chronically underfunded. And actually that really has a knock-on effect because practitioners now are struggling, but also young people are much less likely to want to go into criminal justice when they see these problems. And one of my PhD students, Susie, is actually doing a project looking at how we can get young people involved, what the barriers are to involvement in criminal justice as a profession. But of course, the funding is a big one. And it's not just that you're not getting paid huge amounts of money, it's that people are like kind of struggling on a day-to-day basis. They're working themselves so hard for almost no returns. And I know in my research, I spoke to one lawyer who'd had to give up the criminal justice side of his practice because he said he didn't feel like he could ethically process the cases that he needed to process to kind of make any kind of a living. He had to deal with them too fast, and he couldn't ethically talk to these clients and know he wasn't doing a good job, but he couldn't afford to do a good job given the funding scheme. So that's a huge, huge problem. And it's one of the big problems in my work. So I'm really lucky that I can be involved in criminal justice and I don't have to worry about these things, but I'm so conscious of them. And I'll often kind of be suggesting ideas for reform or ideas for change. And you always then have to scale it back and think okay, but realistically, what is actually going to happen given what the system looks like right now? And all of these great ideas that I have about how the system could change, like anything that's going to cost money or is going to take time at the moment is relatively unrealistic. And I think that that's a big problem. So we need more investment in the criminal justice system once we kind of start to recover realistically from where we are right now. And one thing that I think isn't said enough probably, which can make the case for this funding a bit more strongly, is that if we're not going to be putting funding into the criminal justice system, we can't keep letting these defendants suffer, right? So what we actually have to do is we have to stop prosecuting people.
Yeah.
And that's a big problem. And I think that's going to make the public buy into this a lot more if we say look, there's people who we're going to think almost definitely committed a crime, but we can't prosecute them because we don't have the money to do it fairly. And that's when you really see the system crumble. And hopefully, as that is kind of starting to happen, these ideas for how we can improve the system and this necessity to secure more funding is going to become something that's more realistic.
Yeah, I think as boring or as cliche as it may sound, funding is quite an obstacle and it just blocks all the veins of the system. I guess that's the most alarming issue that needs to be addressed. As we reach the end of this episode, I just want to say that this has been an extremely engaging and interesting episode for me, and I'm sure all our listeners. Thank you so much again, Rebecca, for talking to us today. Back to you, Shania.
Great. So I guess that concludes episode 6 of the Exeter Law Review podcast. I just want to say thank you so much, Rebecca, for coming on here and speaking to us about your work. I think that it shows kind of like the interdisciplinary nature of the law perfectly, which makes everything more complex and obviously at the same time so much more interesting. And it very much shows, I mean, as you said, Rebecca, that the law is being informed by and are made for the human experience, which is just amazing to kind of know and keep in mind, especially when everyone's stressed right now in the current climate. And it's just also so awesome to see students being able to get involved with projects that they are passionate about and having that impact and having the privilege of working with professionals such as yourself, of course. So thank you both, Selin, Rebecca, and everyone working on this project for taking on this very important and very impactful work. So just before we close off, I just want to take this opportunity to remind everyone that we are still accepting submissions for articles to be published on our website. So if you're listening, you have an essay with a mark of 74 and above, and you fancy getting that edited and published, feel free to send it to us at exeterlawreview@gmail.com. So great. Thank you so much for tuning in, and we'll see you on the next episode.